Hello and greetings from SAMVAD. We present to you a 4-part series on implementing Section 15 of the Juvenile Justice Act 2015. Through this series, we will be discussing the law on juvenile transfer in India, in particular the implementational aspects of it. This is especially important in light of the Supreme Court's decision in the case of Barun Chandra Thakur versus Master Bholu. In the third part of this series, we will respond to some frequently asked questions. Who can conduct the preliminary assessment and the psychosocial evaluation of a child in conflict with the law? The proviso to Section 15, subsection 1 of the Juvenile Justice Act states that the board may take the assistance of experienced psychologists or psychosocial workers or other experts to conduct the preliminary assessment. Rule 10A, Sub-Rule 2 of the Juvenile Justice Model Rules 2016 states that for the purpose of conducting a preliminary assessment in case of heinous offences, the board may take the assistance of psychologists or psychosocial workers or other experts who have experience of working with children in difficult circumstances. A panel of such experts may be made available by the District Child Protection Unit, whose assistance can be taken by the board or could be accessed independently. So, does this mean that the JGB need not take the assistance of mental health professionals? In the case of Barun Chandra Thakur versus Master Bholu, the Supreme Court held, given that the purpose of the Act and its legislative intent, that is, to ensure the protection of best interests of the child, the expression may in the proviso to Section 15, subsection 1 thereof, and requirement of taking assistance of experienced psychologists or psychosocial workers or other experts would operate as mandatory unless the board itself comprises of at least one member who is a practicing professional with a degree in child psychology or child psychiatry. The board must record reasons if the preliminary assessment is done by one of its members who is qualified in child psychology or child psychiatry.
Is it possible to conclusively determine under Section 15, Part 1 of the Juvenile Justice Act 2015 as to whether a child in conflict with the law had the mental capacity to commit such an offence and the ability to understand the consequences of the offence on mental health examination years after the date of commission of the offence? Can the preliminary assessment be conducted after 3 months, for instance? The brain is in a state of transition and continues to develop throughout the period of even late adolescence and early adulthood. Consequently, it would be incorrect to assume that the mental capacities, that is cognitive and socio-emotional or psychosocial abilities, would remain the same as age increases. For example, if an adolescent engaged in difficult behaviors and came into conflict with the law at age 17 years, his or her mental capacities a few years later, that is at age 20 or 21 years, would not be what they were at 17 years. In fact, they are unlikely to be the same even 6 months later. This is because the situations that a child is in help change or direct behavior over time, and the environment also influences this ongoing learning experience. So no, it is not possible to conclusively determine whether a child in conflict with the law had the mental capacity to commit such offence and the ability to understand the consequences of the offence on mental health examination years or even months after the date of commission of the offence. Mental capacity is measured cross-sectionally, that is at a given point of time, and it would reflect a child's abilities in that time. Retrospective measurement of mental capacity would thus yield incorrect results because this is logically not possible. We cannot, for instance, today capture the extent of a child's ability to make social judgments and decisions in terms of how it was or might have been a year or even 6 months ago. We can only measure his or her mental capacity in the present time, that is, what his or her abilities are today. Like mental capacities, knowledge of consequences is not a static concept either. Over time, children's knowledge of consequences, in fact, is likely to increase. This is because there is a strong likelihood that following their being apprehended for the alleged offence, the child comes in contact with a range of persons in the observation home and outside and after, such as law enforcement personnel, counselors, and peers or other children. In these interactions, children are naturally likely to glean much information that in some form or the other helps them understand the consequences of their actions. A preliminary assessment that is conducted several months or years after the child has allegedly engaged in the offence assumes that his or her mental capacity has remained unchanged since the time of commission of the offence. This assumption is erroneous, as it is not in keeping with the science and knowledge of adolescent neurodevelopment, since mental capacity is a continuously evolving ability at least until the age of 25 years. Consequently, assessment of knowledge of consequences, like mental capacity, refers to the child's understanding at the time of engagement in the offence. It is therefore also a time-sensitive assessment and cannot be conducted retrospectively. While the purpose of the juvenile transfer law is to understand children's knowledge of consequences at the time of engagement in the alleged offence, preliminary assessments done even weeks or months after and certainly years after the offence are likely to elicit children's current or present understanding of consequences, reflecting all the additional knowledge that they are likely to have gained in the interim. Thus, a retrospective assessment of children's understanding of consequences would yield inaccurate information, as it would not be reflective of the time frame that the law refers to. The recommended time frame for conducting the preliminary assessment test is within 30 days from the date of the incidence of offence. If there are any extenuating circumstances, then the preliminary assessment test may be maximally completed within 3 months from the date of the incidence of offence as per the JJ Act. In the event the preliminary assessment test is not completed within 3 months for any reason, and in the light of the care, protection and rehabilitation objectives of the JJ Act, it is recommended that the child's vulnerabilities are considered in judicial decision making with a view to directing appropriate mental health treatment, rehabilitative and restorative actions for him or her.
How do we interpret mental capacity to commit the offence, ability to understand the consequences of the offence, and the circumstances in which the child allegedly commits the offence? Is there a difference in how we construct mens rea, that is intention or knowledge, in cases of children in conflict with the law, as opposed to adults? According to adolescent neurodevelopmental science, brain maturation during adolescence occurs between the ages of 10 and 24 years, during which time the brain undergoes a rewiring process that is not complete until the age of 25 years. Many studies underscore the fact that adolescents are not yet fully mature and that critical developmental transitions relating to psychosocial maturity occur between the ages 16 and 19 years. While considering a child as an adult, one needs to look at his or her physical maturity, cognitive abilities, social and emotional competencies from a neurobiological perspective. The development of cognitive behavioral attributes like the ability to delay gratification, decision-making, risk-taking, impulsivity, judgment, etc. continues until the early 20s. It is therefore all the more important that such assessment is made to distinguish such attributes between a child and an adult. In the case of Barun Chandra Thakur versus Master Bolu and another, the Supreme Court of India noted, the board and the Children's Court apparently were of the view that the mental capacity and the ability to understand the consequences of the offence were one and the same. That is to say, that if the child had the mental capacity to commit the offence, then he automatically had the capacity to understand the consequences of the offence. This, in our considered opinion, is a grave error committed by them. The relevant portion of Section 15, that is, the ability to understand the consequences of the offence, reads consequences in plural. Therefore, it would not be confined to the immediate consequence, but also those consequences which may fall upon the victim's family, on the child, their family, and also other far-reaching consequences in the future. Implications of terms that are used to establish mens rea, such as deliberate intention, premeditated intention, voluntarily, deliberately, knowingly, recklessly, and negligently, ought not to apply to children and adolescents in the way it is constructed by law for adults, given the vast difference in their neurobiological development. Therefore, the issue of mens rea, as strictly understood in crimes committed by adults, cannot apply to adolescents.
Can the Children's Court conduct the preliminary assessment in exercise of its role under Section 19 of the Juvenile Justice Act 2015? Section 19 of the Act empowers the Children's Court to reassess the preliminary assessment of the board under Section 15. The Children's Court has to determine whether there is actually any need for trial of the child as an adult and pass appropriate orders in this regard. In the Barun Chandra Thakur decision, the Supreme Court clarified that the power to carry out preliminary assessment rests with both the JJB and the Children's Court. It held that the Children's Court on its own would still examine whether the child is to be tried as an adult or not. More recently, in the case of Ajit Gujar versus the state of Madhya Pradesh, the Supreme Court of India held that the observation of the High Court that passed under subsection 3 of section 18 has attained finality completely ignores that the order under subsection 3 of section 18 is not a final adjudication on the question of trying the child as an adult. The reason is that the order under subsection 3 of section 18 is based on a preliminary assessment made under section 15. As such order is based only on a preliminary assessment, the law provides for a further inquiry in terms of subsection 1 of section 19 by the competent Children's Court. Hence, the Children's Court cannot brush aside the requirement of holding an inquiry under clause 1 of subsection 1 of section 19.
Can the order of the Juvenile Justice Board based on the preliminary assessment be appealed? Section 101, Clause 2 of the Juvenile Justice Act states that an appeal shall lie against an order of the board passed after making the preliminary assessment into a heinous offence under Section 15 of the Act before the Court of Sessions, and the court may, while deciding the appeal, take the assistance of experienced psychologists and medical specialists other than those whose assistance has been obtained by the board in passing the order under the said section. As observed by the Gujarat High Court in a successful appeal in the case of child in conflict with law through guardian versus State of Gujarat, this evaluation of mental capacity and ability to understand the consequences of the child in conflict with the law can in no way be relegated to the status of a perfunctory and routine task. The process of taking a decision on which the fate of the child in conflict with the law precariously rests should not be taken without conducting a meticulous psychological evaluation.
Whether the Juvenile Justice Board can decide an application for bail under Section 12 of the Act 2015 even prior to making preliminary assessment under Section 15 of the Act In the case of Prahlad Singh Parmar versus State of MP and others, the Madhya Pradesh High Court held that the power of the JJB to grant bail under Section 12 of JJ Act does not require a preliminary assessment under Section 15 of the Act. The court then scrutinized the provision under Section 18, subsection 3 of the Act and noted that preliminary assessment under Section 15 is to be made for the purpose of trial, and therefore it would necessarily mean that the trial would commence only after framing of charges, and that the bail application could always be decided much prior to that. The Act prescribes limited grounds for denial of bail, and the purpose of conducting a preliminary assessment is not a ground envisaged under Section 12. The High Court of Delhi in Devvrat vs. Government of NCT of Delhi held, it is only if the developmental needs of the child require that he be kept in custody, or that keeping him in custody is necessary for his rehabilitation or care or protection, that his release would defeat the ends of justice, not otherwise.
From a procedural justice standpoint, what are the implications of the pro forma for children in conflict with the law? What about the constitutionally guaranteed right against self-incrimination under Article 20, Clause 3? The explanation to Section 15 states, for the purposes of this section, it is clarified that preliminary assessment is not a trial, but is to assess the capacity of such child to commit and understand the consequences of the alleged offence. How does this work in practice if the concepts of mens rea and mental capacity are conflated? The three-part evaluative framework under Section 15 includes a knowledge component, factual estimation of circumstances, and an undefined element of mental capacity. That is, there is a significant overlap with evaluation and mens rea. It is emphasized here that no admission of guilt should be recorded anywhere on the pro forma to indicate criminal intention, given the possibility of biasing the trial, that is, in case of transfer. The High Court of Delhi, in its order dated 19 September 2022, in the case of Vikas Sangwan vs. State, stated its concerns of non-standardized preliminary assessment methods. The observation of the High Court is produced below. Learned Counsel, appearing on behalf of the NGO HUC, intervener in the criminal reference, has placed before us a copy of the preliminary assessment report prepared by a psychologist in the format supplied by the department. Under Clause 3 of the said report, it can be clearly noted that a confession is sought to be extracted from the child as to the manner in which the offence was committed and the reasons thereof. This manner of seeking a confession from the child is unconstitutional and beyond the scope of a report of preliminary assessment to be prepared under Section 15 of the Juvenile Justice Act. The preliminary assessment pro forma is not a tool or process to extract confessions from children in conflict with the law. It would be a miscarriage of justice and violative of fundamental rights.
Does this methodology for preliminary assessment take a lenient approach towards juvenile offending? What does this mean for public safety? Our belief is not that children in conflict with law should not be accountable for their actions. They should. But accountability does not mean trial in the adult system. It means that children in conflict with law should receive the requisite mental health interventions and life skills education so that their behaviors may be changed, for it is only if this happens that we can move towards our goals of public safety. In fact, research shows lower recidivism rates for children in conflict with law who remain within the JJ system compared to those transferred. And the JJ Act has enough provisions for us to be able to reform and rehabilitate children in conflict with law. The JJ Act also provides for children in conflict with law who might have more severe behavioral difficulties the place of safety option, which allows for both the child as well as the general public to be protected. The child can, within this closed placement, avail of treatment and rehabilitation services more intensively and for a longer duration, thus allowing him or her the opportunity for transformation. So, contrary to what is believed, rehabilitation of the child in conflict with law and public safety are not contradictory agendas. The former is essential to achieving the latter. Can psychological scales and tests be used in preliminary assessments? The first step in any mental health assessment is to get a clinical impression. A clinical impression is based on the history that is taken of the child, a summary and interpretation of information gathered from all the areas of the psychological assessment, vulnerabilities in the child's family and educational background, life skills deficits, experiences of trauma and abuse, etc. It highlights key aspects of the child's problem and is the essence of what is most important to understand about the client. Any psychological scale or test is only used following this initial assessment after obtaining a clinical impression. It is of little use to begin with psychological tests and scales when we have no idea what the child's problem areas are, and we would consequently not know which scales or tests to use or for what purpose. Psychological scales and tests are therefore used for the following purposes: to clarify or corroborate diagnosis, especially where a set of symptoms may be attributed to more than one mental health disorder, to ascertain the degree of severity of the problem, to make decisions about interventions including psychiatric medication, for purposes of certification and related interventions, such as in case of childhood disability, IQ and other tests for disability are administered so as to determine the level of intelligence or disability respectively, so that the corresponding certification may be used to obtain state benefits or make schooling or education related decisions. As the Honorable Supreme Court said in the Barun Chandra Thakur case, a child with average intelligence or IQ will have the intellectual knowledge of consequences of his actions, but whether or not he is able to control himself or his actions will depend on his level of emotional competence. Consequently, the recommendations for use of IQ tests in preliminary assessments are: administer IQ tests only to corroborate a clinical impression that a child might have intellectual disability. This provides concrete evidence that a given child did not have the mental capacity to engage in the alleged offense. 2. IQ tests cannot be a standalone or sole measure to determine children's mental capacities and thus cannot be administered for every child in conflict with the law who's being considered for transfer. Recommendations for use of other psychological tests and scales in preliminary assessments are: 1. Scales for child and adolescent disorders such as anxiety, depression, post-traumatic stress disorder, attention deficit hyperactive disorder may be administered as part of the depth mental health assessments, not in isolation and never before the clinical impression is obtained. The results from the tests or scales may not be interpreted as the gold standard for the child's mental health because many children have subclinical symptoms. That is, they have met some signs and symptoms of a mental disorder, but not enough to meet the criteria for a full clinical diagnosis. This does not mean, however, that they're not suffering from the problems or that they're not vulnerable. In fact, they are at risk, if so far untreated, for these symptoms to develop into full-blown disorders. So for purposes of Section 15 decisions, the test results may help make a case for children's vulnerability. Any projective test such as Rorschach test, ink blot test, storytelling tasks, such as the thematic appreciation test or the Roberts appreciation test, drawings and incomplete sentences can only be used in the context of therapeutic interventions for the child. They may not be used to make legal decisions in the context of Section 15 because the purpose of preliminary assessment is to assess capacity, and projective tests do not assess capacity. Capacity is evaluated through developmental assessments and clinical impressions that seek to understand life skills, signs, and symptoms of mental health disorders. Projective tests do not contribute to clinical assessments and impressions. They primarily have meaning in the process of therapeutic interventions. Can potency tests be used to determine physical capacity in male children in conflict with law who have allegedly engaged in sexual abuse offenses? A potency test is used to prove if an individual in question is capable of sexual intercourse under normal circumstances. It has three major components: semen analysis, penile Doppler ultrasound, and visual erection examination. It has thus far been used in the context of adult criminal justice when an adult male claims that he is impotent and consequently could not have had the ability to engage in sexual crime. It is generally not used in the context of minors. A potency test is a measure of erectile dysfunction, and since these mechanisms constitute normative physiological processes, they also occur in non-sexual contexts. Therefore, it would not be appropriate for erectile dysfunction to be an indicator of physical capacity for offense in the juvenile justice context. Since the preliminary assessment is not a trial, and the mandate of the JJ Act is protection and rehabilitation, any child alleged to have engaged in inappropriate sexual activity would need to be referred for mental health interventions, including life skills education on issues of sexuality and decision making. Is there any way to conclude that rehabilitation would not be effective for a particular child? No, there isn't. Mental health professionals, like everyone else, cannot foretell the future. Unless we provide children with guidance and therapeutic interventions, that is, the assistance and wherewithal to change their behaviors, we cannot expect children to transform. Every child is unique and responds differently to therapeutic and other interventions, so we would need to provide the intervention to allow the child the best possible chance to transform. Rehabilitation orders for children in conflict with the law may comprise of four broad areas: placement, that is, should the child return home to the family? What are the risks of remaining in the neighborhoods with adverse peer influence? Should the child be in a closed placement in a care and protection institution or a place of safety in case the child is between 16 to 18 years are some of the considerations for placement. Vocational training, that is, in case the child has not been going to school or is not interested in continuing education, various types of vocational training may be considered based on the child's interests and skills and what types of trade the child may actually have access to or receive training in. Education is another area for rehabilitation, enabling children to continue education if the child has already been going to school, ensuring that the child receives textbooks and other materials to continue studies while in the observation home, advocating for the child's school admission, making it possible for the child to take school exams in case the child is still in the observation home are some of the considerations for education-related rehabilitation. And lastly, mental health treatment and interventions could comprise of a range of issues: trauma-related interventions to address loss, grief, abuse, and other traumatic childhood experiences, de-addiction interventions for substance use,
and life skills education to address skills deficits pertaining to emotional control and regulation or management of anger and anxiety, decision-making and problem-solving in contexts of stealing, substance use, violence and aggression, decision-making in contexts of sexual and romantic relationships, conflict resolution, assertiveness for addressing peer pressure, and empathy building.